Hello, everyone, and welcome to today's program, Paycheck Protection Program, Legal and Compliance Issues Now and Later. My name is Peter Farley. I'm a partner here with McGuire Woods, and thank you so much for joining us. I want to mention a couple of housekeeping items before we get started. Note that once you have accessed the program, you will find several widgets on your screen. Feel free to explore them at any time during the presentation. I call your attention to two widgets in particular. The Resource List widget on your right includes a copy of the presentation. If you'd like to, you're welcome to save to your desktop or print to follow along during the presentation. This widget includes links to recent alerts and thought leadership created by members of the McGuire Woods and KPMG teams as well. So feel free to save those for accessing after the program. You also should see a Q&A feature to your left. Please use this widget to submit any questions that you have throughout the presentation. Any questions that we do not cover will be addressed following the program, so if we do not have time to get to every one submitted, we will reach out to you individually to ensure your question is answered. You will also find a Bios widget. You can expand this feature to get additional information about each of us and our respective practices. Finally, please note that the full presentation will be recorded. We will be providing a copy of this recording together with the PowerPoint deck after the presentation has ended. If you are seeking CLE credit and provided bar information upon registration, we will be in touch via email once credits are approved. I'm happy to introduce our panel today to cover this important topic and the issues surrounding it. We have a great team of folks from McGuire Woods and KPMG, and I want to just give a few words about each one of them to you. Susan Rodriguez co-leads the firm's Financial Institutions and Industry team with McGuire Woods, which is about a group of about 350 attorneys from both litigation and corporate across the firm, aimed at following industry trends, and the group helps also to serve our bank clients. She is a partner in our Charlotte office, and she has worked at both the U.S. Department of Homeland Security and at the White House. She handles investigations by the OCC, the CFPB, the Department of Justice, and other regulators, and routinely manages investigations and remediation for financial institutions. Mark Krumkowski is a partner in our Chicago office at McGuire Woods and serves as the head of our fund formation and SBIC practice groups. He is also the leader of our community and regional banking and investment industry team, and with respect to today's conversation, has more than 20 years of experience with issues related to the Small Business Administration. Chad Poland is a managing director in KPMG's risk and regulatory and compliance area out of the Pittsburgh office. He focuses on solutions related to consumer compliance and enterprise compliance program transformation, and also leads KPMG's compliance testing services, which include traditional compliance testing, testing for new product deployments, compliance UAT testing, look-back remediation testing, as well as automation-enabled compliance testing. Chad has spent the last 2 months leading an SBA working group within KPMG focused on supporting lenders with PPP execution. And Tom Stanton is a managing director with KPMG's forensic practice in KPMG's New York office with more than 20 years of experience providing clients a wide range of forensic services. He specializes in investigations, fraud, risk management, and regulatory compliance and monitoring in the banking and financial services areas, including alternative investments and government sectors. Thank you all for joining us today, and with that, I will turn it over to Mark to get us started. Mark?
Thank you, Peter. Thanks for the kind introduction. First of all, just reiterate Peter's comments. It's a pleasure to have KPMG with us today and to have been working with them on a variety of issues as sort of this new practice has developed sort of as we look here today, over the last essentially 60 days, 90 days, almost 90 days. We've had a chance to work together, but also sort of really be part of the team that's really analyzing all aspects of the PPP program, both on the lender side and obviously as a law firm on the borrower side as well. This sort of started, and there's been various iterations along the way, but had the pleasure of sort of working through the affiliation issues, which I know many of you on the call had to deal with, especially those sort of within the private equity sector, the SBIC sector, as well as sort of very industry-focused client service teams and groups that were impacted. And now we sort of, as we begin what I'll call the next stage, really talking about forgiveness, as well as talking about sort of the programmatic issues for lenders, and as traditional lenders, but also a variety of alternative lenders that we've had a chance to work with as they have become part of this program, become part of becoming a 7A lender, specialized but still a 7A lender. So just to talk briefly about the agenda, what we're going to go through, Peter had mentioned we will try to take some Q&A. Last count, we were expecting almost about 1,000 people on this call, so we ask for your patience on that, but we will either attempt to get them as we go through, or certainly after, when we hit our hour, or very specific things, we'll try to address that. But just running through the agenda on a high level, obviously talk a little bit about the program. We're going to sort of go with the assumption that everyone on this call is familiar with all the aspects and not a lot of new participants who are exploring, stage one of the program, although I suspect because there are still money available that will happen. Talk a little bit obviously about the forgiveness, and then talk a little bit about the sort of programmatic pain points, compliance issues when we start receiving inquiries of whether for additional information or managing some sort of government or regulatory investigation, whether as a lender, probably, but also as a borrower in certain cases. Talk a little bit about some issues at Cautionary Tales of sort of looking back and looking at some of the historical sort of how people who sort of were lived and were part of the 2008 downturn, and how we looked at that in 9 and 10 and what it looked like in 11 when things were better and they were re-looking at things that happened 3 years ago. So think about that a little bit more and talk about that. Talk about some of the challenges that are out there about the communication, the technology issues, certainly the compliance issues in terms of, most of us are still working remotely and thinking about those compliance procedures and policies, making sure those are up to date and revised. And then I think lastly, talking a little bit about if we do, and if our clients do need to enter into settlements or negotiations with respect to investigations, whether specifically from the government or from an underlying regulatory authority, just talk a little bit about best practices and sort of how, frankly, some of our team members on this call, how they have done it historically, as well as what to expect going forward. So I think with that, we will sort of jump in to, I can hit the slides, there we go. Jump into a little bit just about the forgiveness piece. Won't go through everything, but want to sort of set the table, sort of where we are, how we got there. Right, so the CARES Act was passed. And then I guess it was about 2 weeks later, the SBA and Treasury started, for those of you who have been following this, sort of silently trickling out FAQs and interim final rules, sometimes in the middle of the night, sometimes at 9:30 in the morning after you checked at 8, sometimes late at night after you checked at 10 and you went to bed and thought everything was good for the day, and then a new rule came out, or an FAQ. So the FAQs have been updated as a single document. I think we're up to like 15 different iterations of those, or 16, I guess now. And then interim final rules, very similar, 13, I guess, 14, depending on how you want to count some. Some dealing with very specific items, such as the nonprofit issues, some dealing with specific items about foreign affiliation, things like that. But a lot sort of covering new ground and at least attempting to address either holes in the program that weren't fully addressed in the CARES Act, or modification of the rules, modification of the law by applying a new interpretation to sort of meet the practice, the pragmatic approach that was out there. So we have these two sort of were the initial pieces, and they're still interim final rules. So last week, the loan forgiveness application was published, and what we know of it is, or what we expect, maybe that's a better way. We expect that there will be modifications along the way. We expect that there will be final rules should be issued. There are some that are technically due. We'll see how strict the SBA and Treasury applies to those technical periods, but at some point there will be final rules, and then there will also be pragmatic implementation of it. So that's sort of where we are. Just want to briefly talk about the form that came out and some of the highlights of it. One of the things, and I apologize, it's within the I think the additional resources button. We provided a copy of the act and a copy of a link to the rules, because there are 16 sort of interim rules and FAQs if people are not familiar with that. But then also a link to the loan forgiveness application. And we would expect, as I said, there may be clarifications along that. But some of the highlights, so in this new SBA Form 3508, so some of the highlights and some of the important things I wanted to highlight to this group before we sort of get into additional compliance items is, one of the things was the covered period had been changed. It's still an 8-week period, but there's some modifications to look at. Two things. One is should it really not be 8 weeks? Should it be a specific amount of days? So they talk about that issue. And they also talk, right, if you receive the loan, the distribution was made, it's probably the best way to talk about it, the distribution was made to you, that there's also a way to look at an alternative payment covered period, which would sort of line up with your own regular business payment processing periods. So your regular billing cycles. And there are some other important clarifications and nuances in there, but one of the things that we were seeking clarification and we got was that if something was accrued but not paid during that 8-week period, that if it was paid in the next regular billing cycle, that would count and be part of the question. Or, I'm sorry, part of the potential for forgiveness. The other piece that I think is important probably to this group is the form provides additional clarity about full-time equivalency and provides a safe harbor with respect to if you have a reduction and that reduction has been eliminated before June 30th. So again, some nuances that will happen with that, but wanted to point that out. There's also some specific items which I suspect will need clarification about the documentation, because there will be a problem of sort of getting some of the forms you need in order to file, especially if you go past the end of the quarter. But those will be issues that we'll have to address as we go. And then there are a handful of reps and certifications that will be provided as part of the loan, as part of the forgiveness application. And that piece And that piece will be important as we've sort of gone through this less than $2 million criteria, over $2 million. What kind of certification will you need to give? And for the most part, we think those line up with what the expectations were. So that's sort of the broad program of where we started, where we are with respect to forgiveness. And then I think at this point, I'll turn it over to Chad, and you can take the next piece about, if I can push the slide, take the next piece about some of the pain points involved in the program.
Okay, thanks, Mark. I heard you mention 60 days since CARES Act, or 60 to 90 days. I certainly think for many of us, it feels like, whether it's the quarantine or the 7 days a week from PPP, it feels like about 6 years worth of work that we've put in here over the last couple of months. So happy to be here and talk through some of the challenges we're seeing. So I will just start with the pain points here. I think the first point I would note here is just, what we're experiencing here economically, much different than what happened in 2008, whether it's the cause, virus versus subprime, the geographic dispersion of this. It's global, where 2008 was really U.S. and Europe. The banks now, their focus in terms of support, whereas in 2008 they were in need of a lot of help here. So they're now kind of at the tip of the spear, trying to support through PPP and other relief activities, the recovery here. So despite some of those differing characteristics, I think there's some really relevant regulatory insights that we can all learn when we're talking from 2008 to 2020 here. So the first one here, program urgency. In a matter of days, really from the passage of CARES Act to accepting the applications, there's a lot of work to be done. And I think I heard the numbers, 14 years worth of loans processed in 14 days. So pretty significant effort there. That's dropped pretty significantly recently. I've heard 80 to 90% of the volume that it was during wave one. But because of that urgency, there was a big tech play on the application intake, but also a big push from across the organization, all three lines of defense. And it wasn't your normal second, third line of involvement. I think because of that involvement, the role that the second and third line had in processing these loans, I think we're going to see some additional scrutiny. So important to be considering how you're documenting some of those decisions, the role each of those lines of defense played in the administration of the program, their impact in processing the loans. So I think that's going to be important. And, the regulators, they've dropped some hints about their plans to examine the PPP lending pretty closely. The OCC issued a bulletin. I think they subsequently rescinded it, but then reissued. It's now not a mandate, but they're still urging the banks to document their implementation and lending decisions. So I think we're going to continue to see a lot of scrutiny here around the program, regardless of the actual bulletins out there. But the sentiment and supervision, I don't think will actually change much. So moving on, the unclear and evolving guidance. Part of the program urgency is fed this uncertainty, and as Mark mentioned, kind of the random, silently published guidance that's come out for this. And it's been largely focused, the guidance, on the application intake to this point, and up until just recently, when the loan forgiveness application came out, there really wasn't a process by which to forgive the loans, and that's pretty crazy considering the whole program is designed around the forgiveness of loans. But they did issue the loan forgiveness application, and I think Mark talked you through some of the key points there, the payroll period and the flexibility there, the ability to incur a cost, non-payroll expense paid in the next cycle, some of the rehires. But they've also mentioned there's going to continue to be guidance that's going to assist both borrowers and the lenders in terms of their responsibilities. So I think that's going to happen just naturally, but also there's quite a push from some of the industries to ease the restrictions in terms of the way they can use the funds and the timing and other program changes. So long journey ahead. Continue to have to grapple with some of that uncertainty and how each of these lenders will manage the program and integrate those changes. The PPP funding error. So I would say that the guidance up to this point, and PPP really tried to make an effort to reduce the risk to lenders, and that's for obvious reasons, right, to try and encourage more lenders and get the funds out into the borrowers who need them. But the guidance, while it says lenders are able to rely upon the borrower certification and the documentation they provide, the lenders are still required to certify that they reviewed the documentation, and some of these errors, if they identify them, they got to remediate them, or if they approve some of these loans with clear red flags, there's certainly quite a bit of exposure. So when we're talking defects, error rates across both borrower and the lender processors, it's been pretty significant. I mean, we're talking 25+% for some of these. So with all the changes that have happened, the error rate, there's going to be a really frankly, a tremendous opportunity for second guessing and Monday morning quarterbacking this. So I think what we're seeing now with the volume kind of waning on the application process, a lot of these lenders are thinking about, okay, how do we convert the resources that we had processing these applications to get some level of comfort over what came through? And then obviously part of that QA/QC process is, are we re-adjudicating? Are we going to ask for money back? What's the remediation of the defect process look like? So that QC process is really coming into focus here. And I think just beyond the errors with the significant volume here, from a process excellence and customer experience perspective, I think that the QC can really help out there and certainly support having what I'll call an audit-ready loan and claim package at the end that has all the evidence of the iteration with the borrower and the documentation and decisions that were made. And then the last one here, public pressure. So CARES Act is the single largest small business relief program in history. So there's been quite the opportunity for lenders to capitalize on that volume, but there's certainly some increased risk and responsibility that comes with that. And obviously there's going to be some public pressure, and I think a lot of that's going to be driven by the perception of how successful the program is and who it's helping. Up through the second wave of funding, there wasn't really any demographic data collected, but they did correct that with the PPP, the forgiveness application. So there is a demographic form that's optional, based on what I've heard of after the a couple of days of that being out, is that most lenders are going to utilize them. So it'll be interesting to see what the data looks like. But regardless of the data, I've read and seen a number of legislators who have been speaking out about what they see as lower rates of approval and prioritization for some of the non-minority businesses. You had Elizabeth Warren, her and some others have called for investigations into the distribution of the PPP loans. We've seen the gating lawsuits out there. While nothing's at this point been successful, I think you're going to continue to see those. Just came out, I think, yesterday or sometime earlier this week that the Justice Department has subpoenaed records, and while the banks aren't the focus right now, I think everyone in the back of their mind is thinking that they're going to ultimately at some point get swept up in this. And then, beyond that, you've had some of the recipients of the PPP funds return them, the safe harbor guidance, and then ultimately, we have an election in November, and who knows what's going to happen there. But Joe Biden has said that he's going to have it as a priority to have a comprehensive review of this program. So I think you're just going to continue to see a lot of focus on this. And I think from a lender perspective, the one thing that a lot of lenders are starting to think about is from almost a social perspective, right? How do we manage what we're doing? We've made a lot of money on this. Remains to be seen on the servicing piece how much can be made, but upfront made a fair amount of money here, and want to demonstrate that we're good stewards of the economy and we have the community in mind. So what are they going to do? And I know a lot of them are really thinking about expanding and investing in that QA/QC process to minimize the fraud, waste, and abuse, which Tom and Susan will talk about here in a little. But that's one piece, to invest in the QA/QC and try to keep the regulators happy, audit satisfied, and then also taking some of those profits and investing in communities and in the business and trying to control the message that's out there in the public about your organization and what you're doing. So those are just a couple of the pain points that we've seen over the last few months. Moving on to the risk slide here, there is quite a bit of risk, obviously. I won't drain this slide. I've hit on some of this. I've hit on some of this throughout my discussion already, but I would say the one point on from a compliance perspective is there are an array of risks beyond just the PPP requirements and beyond some of the BSA, KYC stuff that I think has been front and center for this. Lenders need to be thinking about the specific credit overlays they have and some of their activities and how that's going to impact compliance, whether that's calculating the maximum loan amount or the forgiveness or the communications with borrowers, the booking of the residual loan amounts is going to be an issue, interest calculations, payment deferrals, all the ongoing servicing requirements, and then you have the monthly 1502 reporting. So lots to think about beyond just your Paycheck Protection Program proper requirements here. Application prioritization. So they're supposed to be processed first come, first served basis, but I think when you get down to the practical application of that, it's not as straightforward. And within banks, processing times are going to differ significantly between application channel, business unit responsible, there's queuing for the rework of the customer, geography. So it's almost like a true first in versus a white glove first in that you have to manage. So that's another significant compliance risk. Second pillar is fraud. Tom and Susan will talk about this, but I'll just say I've seen the estimates for fraud in the range of 10 to 12%. So we're already at $600 billion for the program, big number. But the interesting thing from the lender perspective is there's a lot of uncertainty around the level of verification and ongoing tracking that may have to go on, and how do we determine, is it truly fraud or is it just unintentional and a non-financial savvy borrower? So like I said, there's some uncertainty there, and certainly want to maintain and do the right things to maintain that guarantee on the PPP loan. Operationally, I think I hit on this a lot, but just with the application phase and how that was approached with the all hands on deck kind of mentality, get the money out, round the clock, 24-hour processing. A lot of these lenders were doing. They had to bring in folks without the technical skills, and I think now that you have some of these folks transitioning into their day jobs, along with processing some of the forgiveness, you're probably going to continue to see that high defect rate and data quality and all the issues that go along with that. Strategic, so change management. We've talked about it, Mark talked about it, I've talked about some of the change. I think making sure you understand that change, you understand how that's going to impact some of your different vintages of loans across the period of the PPP life cycle. How did we treat a loan differently that asked for forgiveness in July versus what we did in November, and how can that impact some of those borrowers? And then there's just the latency from when guidance is released, 10 o'clock at night, like Mark said, and we have this whole queue of loans. From the time till we operationalize that change, how are those loans impacted? So quite a bit to think about there in terms of change management. And then I will just move on to one last slide here, talking about the PPP Forgiveness Timeline. So everyone was kind of at that rapid mobilization point, 60 days ago, even 30 days ago, trying to deal with the second wave of funding. But now I think everyone's kind of coming up for air a bit and starting to think about, okay, what do the coming weeks and months look like for this program? And this timeline is really meant to be representative of the duration a particular borrower could be on, either a shorter cycle or a longer cycle. So the green being the shorter cycle, red being the longer. But the point really is that you kind of need to get the shop open and ready to accept these applications in the beginning here. In a couple of weeks, the first 8-week period will expire, but lenders are going to need to keep the lights on all the way through December and even beyond, likely, if there are some of these other factors listed on the top that change. I mean, the first one, is there additional funding? We've heard $1 trillion is probably the number that's needed for this, but I think you're seeing a little less appetite for the spend here after the second wave have slowed down, and some of the uncertainty with the economy here and whether we're throwing good money after bad, what other options are out there. So I think you might be a little while till we see another round of funding, but there are other potential legislative changes that could push this out even further. And then you have the life cycle that could impact the timing here around the volume. We'll probably see an initial flood of applications for forgiveness, but there will be peaks and valleys throughout the submission window here, which runs through December, through the end of December. And I think I think a lot of small businesses, it remains to be seen, but I think they're probably going to look at this like filing taxes, right? And they're just going to wait till the end. So you might get a flood at the beginning, there'll probably be a lull, and then you'll probably see a lot towards the end. And if you get some submissions in December, there's probably going to be some additional documentation challenges there because 6 months have passed since they spent, and do they have the records? And then you have, on the longer cycle, you have the 60-day window for the lender to make the determination, and expect there will be quite a few of these forgiveness requests that require some back and forth and rework with the borrower, and then the 90-day timeline for the SBA to come back and approve it before it converts into that 2-year 1% loan. So I think the point here is just lenders need to be thinking about the sustainability of whatever their program looks like for forgiveness, because it will run at least through the end of the year and likely beyond that point.
And
so with that,
Chad, just to echo one point.
Yep.
Before we pass it along, one of the proposals sort of floated this morning on CNBC was to extend the 8 weeks to 24. Now, that would be a relatively, so to speak, simple legislative change that might have bipartisan support, but would be a administrative disaster. I'm sorry, a challenge, right? We don't have disasters, we just have challenges. But that could be something that happens, and now you have sort of people thinking about that, and that was solely a comment today that I understand had been floated in some committees, but publicly came out this morning, I don't want to say in a random CNBC interview, but in a random CNBC interview. So echo all of your comments, but just want to throw that out as sort of other things that we're hearing out there, and we'll see how this, which would certainly impact your forgiveness timeline.
Yeah, by no stretch of the imagination are we done with legislative changes and new guidance and rulemaking here. So it will be a journey. Okay, so I will advance the slide here, and Tom, I think you're going to take us through some of these cautionary tales and pitfalls.
I will. Thank you, Chad, and thank you, Mark. The next set of slides, they provide some cautionary tales and pitfalls, some of the things that we've seen so far. So beginning first, when we're on slide 7, when we first look back on May 8th, 2020, the U.S. Select Subcommittee on the Coronavirus Crisis, one of the first official actions they actually wrote were 5 letters to 5 particular companies outlined here. Those companies, EVO Transportation Energy Services, Gulf Island Fabrication Inc., MyMex Group Inc., Quantum Corporation, and Universal Stainless Alloy Products, essentially calling on these companies to return their Paycheck Protection Program loans or produce supporting documentation. This subcommittee particularly characterized these companies as large corporations that have a substantial investor base and access to capital markets, and not the intended beneficiaries of the CARES Act, which were small businesses that otherwise might be forced to lay off employees or shut down entirely. The committee specifically noted that these companies were public, had market capitalization of more than $25 million, had more than 600 employees, and sought and received small business loans of $10 million or more. The concern or the issue here is, though, that the CARES Act does not specifically specify that the criteria or the conditions of the Paycheck Protection Loan Program, and there's really the subsequent guidance and interim rules and frequently asked questions that have been provided by the Treasury Department and SBA. They haven't expressly excluded the aforementioned businesses from obtaining these particular loans. So as Mark and Chad had already alluded to, the Paycheck Protection Program, the eligibility criteria is complex. The frequently asked questions and interim rules continue to be updated and can be confusing. So just a reminder to those on the call, loan borrowers and lenders should carefully and contemporaneously, to get their documents and analyze and use those in order to determine eligibility. So that's our first cautionary tale. And with that, I'd like to hand it over to Susan.
Hi, everyone. So happy to be with you all today. I know we've got a good group of individuals here, both on the lender side and on the business customer side. And this is going to be relevant for everybody on this call because we're already, as Chad and Tom have alluded to, we're already seeing lots of trends in the fraud area. We fully expect, and we're hearing from our financial institution clients that they expect fraud, and that you want to adequately prepare for that. So we're already seeing some prosecutions already in this area, what to look for, and so far it's just business owners, but we'll go through in just a bit some bank executives and bank officers who are charged in addition to business owners, and that was pre-COVID, and how that might, apply in the future. So that's what we'll be going through on these next few slides. One of the first prosecutions that we're aware of happened just earlier this month. 2 people were charged in the District of Rhode Island with filing bank loan applications for PPP, about $500,000. And apparently what they did here is create some of their businesses after the fact in order to get these loans. And one of the information that sort of led to this case was that the IRS didn't actually have a record of employee wages being paid in 2020 for some of the businesses that had actually applied for this loan. So that was a big red flag for them. And ultimately, they had also borrowed some identities. One of the individuals charged borrowed the identity of his brother and then tried to obtain the loan that way. So there were 4 different alleged businesses to be involved here. So the charges were conspiracy to make a false statement to influence the SBA. We've also, in this particular case, seen conspiracy to commit bank fraud. And as I mentioned earlier, since one of the defendants borrowed his brother's identity to obtain the loan and purported to be him, it was aggravated identity theft, which is something we also expect to see here. And the other defendant was charged with bank fraud. Now, we're seeing a variety. These are not just the criminal charges that we expect to be here. There's a variety of things that the U.S. Attorney's offices can charge in these types of cases. We've seen wire fraud before on past cases, which we'll talk about in a few minutes. But this is just one of the first instances, and it'll be a case to follow. We've also seen one, I think we all probably know this one, don't use your PP loan to go out and buy a diamond ring, but not everyone may have gotten that message. So there was a TV reality personality who was down in Atlanta. Some of you all might recognize his name. He was arrested on bank fraud charges when he received a PPP loan, and he obtained in the name of Flame Trucking, but in reality, he was using these loan proceeds to buy jewelry, a Rolex, a diamond bracelet, a diamond ring. There are also allegations that he used the proceeds to lease a Rolls Royce, and also to pay his child support to the tune of about $40,000. Again, I think it goes without saying that these are things that obviously would not be allowed here. But one of the things that I want to ensure you all take away from this presentation is for those who are lenders on the phone, if you catch wind that one of your businesses who's applied for this is using the funds in an inappropriate manner or has made false statements on a loan application, you need to make sure, and we'll talk about this in more detail, but make sure there's an escalation process to review that. Don't sit on that information, because then you might have just put yourself on the hook here for either aiding and abetting or engaged in some conspiracy. Again, those are things that obviously everybody wants to avoid here. So moving along, I'll turn this back over to Tom for a moment to just talk about what's going on with some of the DOJ issues in the safe harbor.
Sure. Thank you, Susan. Yeah, the Department of Justice, as we know, is currently conducting criminal reviews of loan applications under the Paycheck Protection Program. And again, they're looking for fraud and evidence of fraud, as we noted before, in borrowers' applications. And the component of the Department of Justice conducting the review is actually the fraud section. It's the Market Integrity and Major Fraud Unit. They were involved in the last crisis involving mortgage fraud and mortgage-backed securities, and they've conducted broad investigations of large financial institutions in connection with LIBOR and the foreign exchange trading matter that took place. And DOJ, similar to those matters, they are employing data analytics to spot trends and detect fraud. And signs of fraud in loan applications have already been detected, as Susan alluded to and Chad and Marco alluded to before as well. For example, the applications they've seen overstating payroll costs, overstating the number of employees, and overstating the nature of the businesses and the impact that the COVID-19 had on their particular businesses. So just rest assured that the Department of Justice is looking. Recently, as it relates to the safe harbor, as small business owners begin looking towards applying for forgiveness of their SBA Paycheck Protection Program loans, the Treasury Department issued the guidance back on May 13th, and it provides a safe harbor from audits and penalties for companies that received a loan under $2 million. The new guidance was posted again as an updated version of the Paycheck Protection Loan frequently asked questions, and it states simply that, not simply, but that any borrower that together with its affiliates received Paycheck Protection loans with an original principal amount of less than $2 million will be deemed to have made the required certifications concerning the necessity of the loan request in good faith. And SBA has really determined that this safe harbor is appropriate because the borrowers with loans below this threshold are generally less likely to have had access to adequate sources of liquidity. And previous to this guidance, many companies were worried about that under the good faith certification requirement on the Paycheck Protection Program lending application, that they would be subject to SBA or Treasury audits and potential penalties and damages. And hopefully, as it relates to this safe harbor, this will provide those companies that are seeking loans for less than $2 million to less worry in terms of the audit and possible penalties for not meeting this good faith requirement. And, however, despite, as Chad, Mark, and Susan alluded to before, despite this needed safe harbor, many questions still remain about the Protection Loan Forgiveness Program, which will need to be answered by the future Treasury guidelines. And Susan, I think you wanted to touch on the last point.
Yes, thank you. We also just wanted to make everyone aware on the phone. We're also hearing that the SEC has already sent out some voluntary requests for information to several public companies that obtained PPP loans for more than $2 million. So it appears that the SEC is looking at the accuracy of the good faith certification. It seems like most of those companies, as far as we know, some of this has been publicly reported, that those responses are in progress right now. We don't know where that's going to take the SEC or if they're going to come out with additional information on that. But I think that's definitely one to follow. And for those on the phone that are lenders, you may want to alert either your folks who handle, regulatory requests or subpoena requests, to be on the lookout for issues like that come in to make sure that they get appropriately routed and can be appropriately responded to. That also goes along with this next slide here that we wanted to come out. This just came out yesterday, and news report was that the Justice Department has already began issuing subpoenas for some of the brick and mortar institutions for small business loans. And so we just wanted to make everyone aware of that. There's a couple of things y'all might want to go back and look at the article after we conclude with this presentation. But, there were a few interesting tidbits in the article. One of the sources, who was unnamed, said, right now we don't think that banks are 100% the target, but there are concerns that there will be a boomerang effect 6 months down the road on banks that they didn't do enough. And when I read that quote, I thought back, many of you all remember, the 2008 crisis and sort of the downturn and all of the fallout that came along with that, after that downturn. And I think all of us on the phone fully expect something like that to happen here, where there are government investigations about banks' roles, what was known, what was not known. Now, of course, the other interesting points that the article made is, many lenders were trying to lobby, and, we're trying to do so successfully on, that it could rely on borrower certifications to a certain point and, to specify documents to determine their eligibility and the use of the loans, and the bank could be held harmless if the borrowers broke the rules or if they lied. But the article goes on to say, and, I think this is kind of interesting, is that even though, banks could be held harmless in those situations if they're relying on the borrower certification, it still wouldn't preclude the Justice Department from pursuing the banks if they found evidence or identified patterns that suggested the loan officers or, bank employees facilitated the fraud, or, and again, this is what I want to emphasize for you all, willfully ignored it. And I think that's an important point. Another angle to this to just think about for a moment is the AML, aspect of this. Of course, banks are required to have their AML programs and checks into place, and how that applies to credit and, knowing your customer. Just to make sure that you're looking internally about how all of those processes are interacting. I think that's something in the background we can, discuss on compliance, but, making sure that internal efforts are coordinated to make sure that you have sound processes in place. Now we'll go on to the next slide, because I mentioned earlier there were some pre-COVID-19 SBA loan fraud cases that I think are very instructive on some of the pitfalls to avoid and what not to do here. And just attach a couple of the cases. There are actually more cases than this, but I think these two sort of highlight the issues that I want to cover for you all. In one of the cases that I put on the slide there was an executive vice president and a chief lending officer who pled guilty and was sentenced to 3 years in federal prison without parole. He also paid about $4.2 million in restitution. And so that underlying charge was a conspiracy to defraud the SBA by obtaining loans that were, of course, guaranteed, and the loans were fraudulently obtained by the businesses by, concealing certain information, that they had past due loan payments, that they were making loans to nominee borrowers, that they were making false entries in bank records, that they were structuring loans so as to avoid the scrutiny of the bank's board of directors, that they were concealing unbooked letters of credit. There was also allegations, again, that he ended up pleading guilty to, of funneling SBA guaranteed loan proceeds to themselves and others, misapplying loan proceeds, and preparing fraudulent SBA borrower applications. Ultimately, we all know on this call not to do this, but that accepting bribe money, that was also another component of that particular case. But I want to underscore, too, in this pre-COVID case, it wasn't just the executive vice president and the chief lending officer who were charged, but there were many others charged in this particular scheme, including a branch manager, several business owners for their role in approving, submitting false paperwork, and then, of course, the bank employees for their role in approving the funds, knowing that some of the paperwork contained false statements. So, again, just a cautionary tale, especially when you've known clients for a long time, who, you may know their specific situations. And if you have reason, again, to believe that some of the statements contained in their application are false, again, make sure you've got a good process in place to address those issues. The other one is, the other case here is also interesting, again, pre-COVID, but 2 bank officers and a bank customer were charged with fraud and falsifying statements to the SBA. There was about a $3.9 million loan application to the SBA, and it actually contained false statement and concealed some material facts. One of the interesting things about that case was there was an allegation that some of the loan proceeds were meant to refinance another loan, and that the bank executive knew that but chose to ignore it. And, that is something that could come up very frequently here with the PPP loans. And so that's something also to be on the lookout for, and just a cautionary tale of course, the situations that we don't want to end up in, with some of our borrowers. I'll move on to the next slide, and I'll turn it back over to Tom to talk about some of the compliance considerations and some of the measures that you can put into place now.
Thank you, Susan. And obviously, based on these cautionary tales and pitfalls, some of the key questions that lenders and borrowers want to ask the compliance team is really, have you reviewed your current policies to determine whether any updates are needed? Have you reviewed your current procedures and checklists to determine whether any updates are needed? And have you provided training and provided updates to employees on the latest guidance? As Mark and Chad and Susan alluded to, the guidance is changing. Interim rules, FAQs are coming out time and time again. So make sure you provide that updated training. And then lastly, a point that Susan just touched on is, do you have escalation processes in place? You know a lot about your client, and if you've got question or reason to question something, make sure that gets escalated before people get in trouble. So with that, I'll hand it back over to Peter.
Thank you very much, Tom, and thank you all for covering some very complicated issues and a landscape that's continuing to constantly change. I think we have time for a couple of questions. One that came in was just some suggestions for best practices from a change management perspective, and I think this touches on a couple of the issues that you all are likely concerned about. And Chad, if you would just take a moment and answer that and highlight a few best practices that you all are seeing from the KPMG perspective, I think that would be very helpful.
Yeah, I mean, this is what it all comes down to, right? Being able to have a good, robust change management program in place that identifies the issues early. So you have to have, people dedicated to identifying the issues. And once you do, it's got to be those changes. You have to understand the impact across the people, process, the technology, and how you're going to adapt your adjudication process for forgiveness to comply with these new guidance and requirements. And I think one of the big things are being able to do like data-driven scenario analysis to, as I was saying earlier, about the difference between a loan forgiven in June or July versus one forgiven in November or December, and being able to look back and quickly have the data and run that analytics to say, okay, if we were to apply this current guidance to a loan adjudicated back in July, what would that look like? Would it harm the borrower? So being able to do that is, I think, a big key. Having your technology that you're likely going to stand up be low code, dynamic, and quickly able to integrate those updates. The training, as Tom was just talking about, being able to push out that training quickly and having a comprehensive program around the QC to make sure that as we start to adapt our processes that we're doing it correctly. And then having a real robust methodology. I think those are some of the things I would highlight around change management, but it's certainly that's the key here. There's going to be a lot of changes, and being able to integrate those changes efficiently is really what's going to be the driver for success here.
Great. Thanks very much for that, Chad. another question that we have that I think try to look a little bit into the crystal ball, Mark, if you could, and talk about just the expectations or some indications of the additional guidance on loan forgiveness. I know you touched on the way that guidance and interpretive regulations, et cetera, has been trickled out. The first one being, the 75%, 25% rule, however you want to look at it for payroll costs. But what are you seeing, or what do you understand get the time frame and the scope of additional guidance maybe for the PPP program?
Thanks. I suspect that we'll have a similar FAQ with respect to forgiveness that will happen. I did not check between this morning and this starting of the conference call to see if they actually had already issued something. But I suspect it will be a similar process. I also suspect that the interim final rules will become final rules at some point. And will there be changes there that impact the forgiveness? For as many questions as they attempted to answer in the actual SBA form, they certainly did not answer all of them. And I'm not quite sure. I'm not quite sure how I should read that they submitted the form and that it expires on 10/31, which is Halloween of this year, when all the forgiveness may not actually be pushed through the process. Sometimes you can read into those expiration dates. Sometimes someone just picks something without sort of fully understanding what the difference or distinction might be. I don't have a good insight into that, but those are things that I suspect over the next couple days and then weeks, and I know there's various industry trade associations that have been active and will continue to be active in trying to help their clientele, frankly, lender and borrower equally, sort of navigate these rules so that at the end of the day, the certifications are true and correct, and sort of they serve the purpose that the program was the implementation serves the purpose of how it was passed by Congress. So we'll see how that plays out. I'm not sure that's a great answer, but that's probably the best answer that's out there today, and something that both the KPMG and the McGuire-Woods team will continue to monitor and try to provide as live updates as we can on our websites, and obviously anytime we can help serve any of our clients or new clients, happy to do that.
Well, thank you very much, Mark, and Susan, Mark, Chad, and Tom. Thank you for a wonderful presentation going over a diverse set of issues and concerns that folks may have. On behalf of McGuire-Woods and KPMG, we want to thank you all very much for attending our program today. As I mentioned at the outset, a recording and a copy of the presentation will be available after we're done. And to the extent we didn't address a question, we will endeavor to get back to you on that. But with that, once again, thank you very much for joining us today, and we hope you have a good rest of your day.